Good morning. Morning, ladies and gentlemen. On behalf of the Jamaica Chamber of Commerce, let me extend a warm welcome to all our online participants. This morning's webinar is being staged in partnership with DunnCox Attorneys-at-Law under the theme Work Against Sexual Harassment in the Workplace. Our presenters are Mr. Jonathan Morgan, partner and attorney at law, and Ms. Paulette Neal, partner and attorney at law. To give you a brief outline, the 2021 Sexual Harassment Bill has now been approved by both houses of Parliament. The legislation contains specific requirements for employees to take active steps to prevent, avoid, or address occurrences of sexual harassment in the workplace. Legislation also outlines procedures for employees to make complaints or to deal with incidents of sexual harassment at work. This morning's presentation will simplify the obligations and entitlements set out in the new Sexual Harassment Law. The presenters will also assist employees and employers with identifying incidents of sexual harassment and implementing policies and procedures for preventing or addressing those incidents in the workplace. Specifically, the presenters will cover the following areas: defining and simplifying the law on sexual harassment in the workplace, designing a cogent policy to prevent and address harassment in the workplace, dealing with complaints and alleged incidents of sexual harassment, imposing disciplinary measures and sanctions on perpetrators, and introducing a support structure for victims of harassment. Questions and/or comments will be facilitated by our chat room at the end of the presentation. I must mention our deep appreciation to our sponsors, CARMED Limited and IGL Limited, without whose support this event would not have been able to be launched. And for our attorneys at law who are present on this webinar, you're asked to note that the Jamaica Chamber of Commerce will be submitting the documentation from the webinar to the General Legal Counsel for consideration of continuing education credits. Please complete the evaluation form and submit same via email to andrea.waite, that's andrea.waite at jamaicachamber.org.jm. So that's andrea.waite at jamaicachamber.org.jm. Participants will be given the opportunity to win gift baskets from our sponsor, CARMED, by participating in the webinar. At this time, I'll now hand over to our President of the Jamaica Chamber of Commerce, Mr. Nito, who will introduce our presenters.
Thank you so much, Chris. Thank you. And I'd like to just add my own warm welcome to all the participants. It's a delight to see so many of you joining us to have a discussion about this very, very important matter. And we are pleased to have two partners from DunnCox with us today, which I would introduce. I begin with Paulette. Paulette Neal has a multidimensional legal practice which covers civil and commercial litigation, employment disputes, conveyancing transactions, and commercial law. Paulette was admitted to the Jamaican bar in 2014 and joined the DunnCox in 2017, where she oversees the firm's Montego Bay office. Prior to joining DunnCox, Paulette oversaw and managed a branch of a Jamaican firm and gained experience in areas such as employment law, civil litigation, personal injury, divorce, and family law. Paulette also gained experience in the area of property law while holding the position of regional branch manager for a private land management company whose main function related to obtaining registered titles for its customers. Throughout Paulette's studies, she has held executive positions on student bodies and was actively engaged in outreach activities. Paulette is currently a member of the Cornwall Bar Association and the Jamaica Bar Association. Paulette is also a director of the Montego Bay Chamber of Commerce. On to Jonathan Morgan. Jonathan was called to both the Jamaican and Trinidad and Tobago bars in 2014 and is a member of the Litigation and Alternative Dispute Resolution Department at DunnCox. His years in practice have been spent in leading and supporting roles in complex civil and commercial litigation matters. Jonathan's commercial litigation experience includes acting on behalf of financial institutions, insurance companies, construction and mining companies, and other major players in corporate Jamaica. His practice covers a broad array of litigation matters, including property claims, debt collection, labor disputes, and contractual disputes. Jonathan has also played a pivotal role in advising corporate entities on labor issues and areas of regulatory compliance. In his formative years, Jonathan demonstrated early signs of prowess for legal research and advocacy by participating in the 2007 Model United Nations Assembly in Trinidad, the 2009 Youth Forum of the 5th Summit of the Americas in Trinidad, in 2009 Youth Forum of the 5th Summit of Americas, the 2012 World University Debating Championship in Antalya, Turkey, and in 2013 and 2014, the Philip C. Jessup International Moot Court Competitions in Washington, D.C., USA. Jonathan is a former president of the Youth of the United Nations Group, Trinidad and Tobago, and has served as a volunteer of both Circle K International in Barbados and the Youth of Rotary International in Trinidad and Tobago. So help me welcome these two legal luminaries. Thank you.
Thank you, President Ianito, for that introduction. Good morning, everyone. Now, the subject area of this presentation is one that is very relevant. It is important, and it is a very topical area. Now, in 2021, an important piece of legislation was passed in both the House of Representatives and the Senate, and that is the Sexual Harassment Protection and Prevention Act. Now, this piece of legislation, it has been signed off by the Governor General. That means it has been given the Governor General's assent. However, this legislation has not yet been given a commencement date. So it is not quite yet in effect, though it has been passed. It is only a matter of time. So it's not when, it's not if, but when it will take place. Now, the purpose of this presentation is to sensitize you, the business community, as to what is to come and to prepare you, as it will take a culture change. Our theme for the presentation is Work Against Sexual Harassment in the Workplace. And I would say we are the future of harassment prevention. Now, sexual harassment is a topic that it is very difficult for me to present on this topic without interacting directly with my audience. And as such, throughout the presentation or at specific intervals, I am going to invite you to provide feedback by typing in the chat section your comments. If you have questions, however, about the presentation, we ask that you save the questions until the end where we have a question and answer segment. So on this first slide, there are 4 images. And this is for this slide, I'm inviting you as participants to share whether or not you consider these images displayed on the screen as sexual harassment. So let's examine the first image. Again, I'm inviting you to type in the chat section, is this sexual harassment? And if so, why?
I know that when Paulette showed me this slide, I asked if we could give you a bit of characterization of what is in the image. Paulette said no, she wants the audience to decipher it and to say for themselves. What do you think about these 4 images? And do you consider the depiction to be evidence of sexual harassment? An easy way to respond is to give a number, say image number 1, your answer, yes or no, and a 1-line reason. And our team will read your answers and we will help you decode whether you're right or wrong. I'm pretty sure.
With respect to image number 2, if it is that you can't read what is being said there, it says, there's a gentleman on a call and he says, hold my calls. I see something I have to handle. Now, is this harassment? Is it sexual harassment? Do we have any comments in the chat section? No comments so far. Okay. So
can I give answers?
Sure.
I do believe that item 3 looks like harassment, but it's a woman pinching a man. Can you tell me if that is sexual harassment or if it's just friendly banter between office colleagues?
We received 2 responses, one from Tanara Dunbar, which says that yes, they are leering, and Cabell Satchel says all of them are depicting sexual harassment.
Okay, so there's somebody who's saying that all 4 images are depicting sexual harassment. The first image, we can see where 2 gentlemen are speaking. There's a lady in front and she's obviously hearing what they're saying. She has a smile on her face. You know, she doesn't appear to be uncomfortable. She appears to be pleased with whatever is being said. Now, is this harassment? Let us look at image number 2. There is a lady, obviously it is an office setting. She's watering the plant and the position that she's set in, the gentleman is obviously staring at her, but can she see that she's staring at her? And he says, hold my calls. I see something that I have to handle. Is this sexual harassment? Image number 3, we're seeing a physical touch. We're seeing a female pinching a gentleman. Does it matter that it's a female who is doing the touch? Should it be a male? Does it really matter? Is this sexual harassment? Image number 4, we can clearly see one individual is showing another individual something which appears to be something on a phone. Now, the person says to the other, look at that body. So we have some insights as to what is on screen. And if you look at the other person who is being shown that image, look at the facial expression. From the facial expression, I can tell that this person is uncomfortable. The person says or thinks, when will this end? Now, is this harassment? Is this sexual harassment? Is this behavior, is this conduct permissible in a working environment? We have some comments. Tony Spencer says, image number 1, not sexual harassment. She says image number 2 and image number 3, yes. Image number 2, no. Image number 3, yes. Thank you for those comments.
Just to be clear though, Paulette, will you fill us in before the end of the presentation, your view on these photos?
I will relate back to the images throughout the presentation.
Okay, good. I don't want to be left on a cliffhanger. Thank you.
All right. So generally, in the workplace environment, sexual harassment comes in these forms generally. So it could be in the form of holding the hand of a fellow employee. It could be in the form of touching a fellow employee, or hugging another employee, or speaking to another employee in a suggestive way. These are all forms of sexual harassment in the workplace. We would say that sexual harassment is in the eye of the beholder. And this is an adaptation of the phrase, beauty is in the eye of the beholder. So it doesn't matter about what the person who is doing the particular conduct, whether they believe it is harassment. Because if we look back at the image, the earlier image number 4, right? You could see the person who is showing the image on the phone, clearly that person is smiling. They think that whatever they're doing is fine. The other person, on the other hand, seems uncomfortable. So it is about whether that individual who is being shown the image, whether that individual considers this conduct by the other employee harassment. So it is very subjective. What might be harassment to me may not be considered harassment to Jonathan. And what might be considered sexual harassment today may not be considered sexual harassment tomorrow. So it is very subjective. Now, the legislation, the very important piece of legislation, the Sexual Harassment Protection and Prevention Act, and by its name, it is geared at protecting and also preventing sexual harassment. So the act provides a definition of sexual harassment, and sexual harassment is defined as the making of any. So any literally means any form of unwelcome sexual advance. And if it is unwelcomed, that means it wasn't invited. And sexual advance has been given its own definition in the act, and we will get onto that definition shortly. So it is an unwelcome sexual advance towards a person by another person. You notice here, it didn't say towards a male or towards a female. So it is gender neutral. It could be a sexual advance by a female towards a male, or a male towards a female, or even a male towards another male. Any combination of those could be considered sexual harassment if it is an unwelcomed sexual advance, which that person believes it is reasonably regarded as offensive or humiliating by the person towards whom the sexual advance is made. Now, something that we have to bear in mind in a workplace environment, we're all coming from different backgrounds. We were all brought up differently. Jonathan is coming from Trinidad and Tobago. I am Jamaican. I was brought up in a Jamaican environment. Jonathan was brought up differently. However, we both work in the same environment. What may be considered sexual harassment to Jonathan may not be considered sexual harassment to me. Also, we share different life experiences. A person may view a particular conduct as sexual harassment mainly because of a particular experience they shared, and we may not know these things. So in the context of your employment, you have to always try to maintain a professional being at all times. Next slide. So the legislation also speaks to the effects in the definition. So the sexual advance has the effect of interfering with the work performance of a person to whom the sexual advance is made. So have you ever been in an environment and it is just tense? It is uncomfortable. So it is that same sort of effect that sexual harassment has. It creates a very tense and uncomfortable environment. It affects the person's performance at work. It also creates an intimidating, offensive, or hostile working environment. And that is not something, that's not the type of environment we want to foster in our businesses. Now, the legislation defines sexual advance to include any one or more of the following acts: forms or conduct or behavior, namely. So it could be a physical contact of sexual nature. So looking back at the image where the lady had pinched the gentleman on his bottom, that's a physical act. And in my view, it is one of a sexual nature because she's pinching the gentleman's buttocks. It could also come in the form of a demand or request for sex or for favors of a sexual nature. So if you do this particular act for me, right? As Jamaican, if you just give me peace, right? It also comes in the form of the making of sexual suggestions or remarks or innuendos. As Jamaicans, we like to say, or we like to compliment women, or men generally like to compliment women in a particular way. You know, you see a lady wearing a nice dress, you say, boy, the dress sit down for you, it's sit down for your body, right? That is it is a suggestion in a sexual nature. It is describing, it is speaking about the person's body. It sits down on your body. It also comes in the form of showing of pornography or the display of images or objects of a sexual nature. Again, I go back to our images on the second slide. Image number 4. Something is being shown on this phone and the other person is clearly uncomfortable. It could be something of a pornographic nature. Who knows? So it could also be any other physical, gestural, verbal, non-verbal, or visual conduct of a sexual nature. So these are all forms of sexual advance. So to simplify it, and in other words, sexual harassment is the misuse of sexual behavior. So if something is being misused, there's also a proper use of sexual behavior. Now, what do you think would be a proper use of sexual behavior? 2 consenting adults, they consent to sexual behavior, that would be proper use. Once there is consent, right? Sexual harassment could also take the form of a request for sexual favors. We had touched on that before. It could be a verbal statement or physical actions or gestures that describe a sexual act. It could be something unwanted or unwelcomed. It's an unwelcomed action of a sexual nature where, next slide, the recipient has made it clear that the behavior is unwanted. Now, the recipient may not always make it clear that the behavior is unwanted, right? The person may not be somebody like me who may say no, you know, respectfully, I am not comfortable with you saying that, I'm not comfortable with you doing that. But sometimes based on the situation, the person may not make it clear. In image number 4, the person said nothing, but they had a thought. Based on the thought and the facial expression, it was uncomfortable. It also has the effect of making the recipient feel humiliated or offended or intimidated by the conduct. And the perpetrator should have reasonably anticipated that the other person would feel humiliated, offended, or intimidated by the conduct. Sometimes sexual favors are linked to career advancements. So you know that, boy, if I do this thing, if that person gets ahead, I will get ahead too. So types of sexual harassment, physical harassment. There are so many types. There's non-verbal, there's gestural. So if every day I come to work and I see Jonathan and I make eye contact with Jonathan and I go like this, right? Is that sexual harassment? I'm not saying anything, but I'm making a gesture. It could be psychological or emotional harassment. You know, a person could be put in a hostile working environment to the point where they go home and they can't sleep at night. It has a psychological effect. It could be visual, written, or graphic harassment. If, for example, you are at work and you're displaying certain images on your laptop screen, right? Even though it is your laptop, you're working on it, there are other persons who may be passing you by and they may see this image. Could that be harassment? And of course, there is verbal harassment. Now, not only is there physical harassment and verbal harassment, there is what we call cyber harassment or cyber stalking. So if you know your coworker has an Instagram page and you run into their DMs, you message them, you comment on their photographs, right? Could this be considered harassment? Voyeurism. Let me give you an example. If you see your coworker going to the restroom, let me go and take a look. Unintentional sexual harassment. I don't know if you're familiar, or many of you should be familiar with the former New York governor, Andrew Cuomo. And we all know that he was accused of sexual harassment. And his defense was, it wasn't harassment. That's how we behave, right? Based on his culture. You know, some persons, if you're from a particular culture, you're Italian, Italians are used to hugging, greeting people by hugging and kissing on the cheek. You know, to another person, if you come to me, for example, and greet me with a kiss on the cheek, it may not come across as welcoming. It could be unintentional sexual harassment. Another form of harassment is intimidation or bullying. Because this person is your supervisor or your manager, you feel forced, you feel compelled to do this particular act. Quid pro quo. Now, an example of this, you're a new worker, you're on probation, your probation is about to expire. Your supervisor, who will make a recommendation as to whether your employment is to be confirmed or not, says to you, you know, if I take you on a date, your employment status will be confirmed. Now, is this harassment? Now, to consider whether any conduct, any act or behavior constitutes sexual harassment, all the circumstances must be taken into consideration. So, for example, if I come in to work every day and I greet somebody a particular way, I say good morning. I greet Jonathan that way. Hi, good morning. I see Roxanne, I greet her. Hi, good morning. But this other particular person, I say hi, good morning, and this person says, oh, I'm not comfortable with the way I am saying good morning, or I've waved my hand, I'm waving at them. Now, examine all the circumstances. This is a generic term, good morning, right? People wave sometimes when you say good morning. it is something that I say to not only this particular person, but to many other persons in the work environment. So is this sexual harassment? It's unlikely that it would be deemed sexual harassment. So all the circumstances must be taken into consideration. Look at whether it is a course of conduct, if it is a single instance or it is a series, you know, whether it is sufficiently serious to be so deemed as harassment. And the determination as to whether a particular conduct is considered sexual harassment is based on the findings in that particular case. Now, the Act, what does the Act do? It creates a sexual harassment tribunal. Many of you may be familiar with the IDT, that's the Industrial Disputes Tribunal. That tribunal deals with dismissals. Now, the Act creates the Sexual Harassment Tribunal, which will deal with complaints about sexual harassment. The Act extends liability to contractors. So not only will an employer will be held liable for the actions of its employees, but it could be held liable for the actions of a contractor. So if you engage, for example, an AC technician to come and service the ACs at your office, and that AC technician sexually harassed another employee, you could be held liable as an employer for the conduct of a contractor. The legislation creates a framework where workers can have recourse outside of the workplace if they have been a victim of sexual harassment. So it provides an alternative avenue to make your complaint. The Act also requires employers to have a sexual harassment policy. And Jonathan will divulge some more about the sexual harassment policy and what should be contained in this policy. The Act requires an employer to take steps reasonably required to bring the policy to the attention of its workers. Now, there are certain terms that are defined in the Act. A contractor is defined as a person who is hired by an employer to perform specific work or provide a specific service for compensation or reward. So I just gave an example of you hiring, or an employer hiring an AC technician to come in and service the AC. That is an example of a contractor. A client, a person who conducts business with an employer. So for example, if you operate a hotel, your client will be the guests. A supervisor is defined in relation to a worker means a co-worker who, by the virtue of the co-worker's employment, is in a position of authority over that worker. So these are some important terms that are defined in the Act. Who is a worker? The definition of a worker is very wide. It includes a person who carries out work in any capacity for an employer, including a public or private sector employee. It includes a domestic worker. It includes a person engaged under a contract for services or a subcontractor of that person. It includes an employee of the person or subcontractor. It also includes a person whose services is procured or arranged by a company that supplies labor. It includes an apprentice, a student gaining work experience, or a volunteer. So, you know, if you have a volunteer coming, a student coming to perform a task at your workplace, you know, that person is doing in-service training, for example, for 5 weeks. It doesn't matter the length of time. The Act considered that individual a worker.
So what we've heard so far, quite ably put by my co-presenter Paulette, is a description of how sexual harassment is defined and how we can identify instances of sexual harassment in the workplace. So we've gone through traversing a couple examples that illustrate instances of sexual harassment and instances that may not be sexual harassment based on the definition. But what we need to identify is what is the practical consequences for the company or for the employer in light of this legislation that indicates we must all be preventing those instances of sexual harassment. These last few definitions indicated that sexual harassment can take place from a worker to a worker, from a worker to a contractor, from a client to a worker, from a supervisor to a worker. All of these different types of sexual harassment occurrences are governed by the legislation. And the legislation puts in place specific requirements outlined in summary on this slide as to how we should put steps and measures in place to prevent sexual harassment in the workplace. So what does that mean in a practical sense? And this is the area that I will be covering. In a practical sense, it requires first that companies introduce a sexual harassment policy. Now, we all should be very familiar with HR and labor policies that should be introduced in corporate structures. And those policies are designed first to protect the labor force, to protect the workers. But in this case, it is my humble opinion that a sexual harassment policy will also protect the employer. It allows the employer to satisfy its obligations under the Act, to avoid difficult and challenging occurrences in the workplace that could create issues for the employer. And generally, it will create a safer and more productive environment for the fruition of the workforce and the fruition of the labor that they wish to promulgate. So what should a policy say? First, of course, it should define sexual harassment, and Paulette gave an accurate definition of that term earlier in her presentation. It should also state the entitlement to an environment free of sexual harassment. And what that means is that the company must create a policy that outlines this entitlement. Yes, I believe that we were kicked off the platform for a moment. It appeared as though JPS is not our friend today. We had a little power outage, but it seems as though we're back. So right before the interruption, I was describing the content of a sexual harassment policy, and that in a definition of sexual harassment as indicated by Paulette earlier. One of the core parts of that definition is that sexual harassment is unwelcomed sexual advance. And we know that sexual advance could be physical, verbal, non-verbal, etc. But any unwelcomed sexual advance between one person and another is considered under the Act to be sexual harassment. The policy should also state the entitlement of the workforce to an environment that is free of sexual harassment. And while we, as employers, typically put these things in place on paper and feel as though we have satisfied our obligation, what this section speaks to is deeper than that. It speaks to a requirement to create the environment itself, create the atmosphere where your workforce can feel comfortable. They can feel as though the occurrences and incidents of sexual harassment will not go unnoticed. They can feel confident that any disclosures of sexual harassment will be kept confidential. And of course, it is the type of environment where the workers will not be penalized for coming out to say that this negative sexual action has taken place. So while we have here that the policy should state the entitlement to an environment free from sexual harassment, it's more important to create the environment. It's more important to put the things in place to ensure that your workforce feels that type of sexual and personal security. The policy should also set out disciplinary measures that will be taken for any breach of the sexual harassment legislation or any breach of the sexual harassment policy. And it should refer to the due process steps that the company intends to take to investigate and to penalize the offenders. The policy should also set out the complaint process and how complaints may be resolved. This is very important because the initial complaint process is a local one. It is one that takes place within the four corners of the company before it goes outside of it. When we speak about the complaint process going outside of the company, it is a reference to making a complaint to the Sexual Harassment Tribunal that we will describe further later. So the policy should also state the following. It should state the employer's obligation to confidentiality, as I described briefly a moment ago. That obligation is one that requires the employer to keep any complaint from an employee confined, private, and secure in a manner that does not allow it to be disclosed to third parties. The Act goes on to specifically identify areas in which it can be disclosed, and those include for the purpose of investigating the complaint, for the purpose of informing the party against whom the complaint has been made, and for the purpose of filing any documents through disclosure at the Sexual Harassment Tribunal or at a court of law. So the obligation here is to keep sexual harassment complaints confidential, but the Act lists specific areas in which those complaints may be disclosed for very narrow purposes. The policy should also set out the right of redress of workers to the Sexual Harassment Tribunal. And this one we certainly can give a bit more detail on. But the policy should also set out that all internal procedures must be exhausted before the complaint can be taken to the tribunal. So it is Section 27 of the Act that identifies the procedure for making a complaint to the tribunal. And as employers and as managers of a workforce, it is important that we consider the consequences of that procedure. For example, if a sexual harassment incident occurs between an employer and an employee, where the employer has approached the employee inappropriately, that employee has up to 6 years to bring a complaint to the employment tribunal. And since the offending actor is the employer, the Act provides that the employee can forego the complaint process within the company and go straight to the tribunal. So what this means is, as supervisors or as managers, it is very important for us to be even more vigilant than the co-workers amongst us, because we will not know if some statement, some action, some verbal or non-verbal gesture to an employee was taken as an unwelcome sexual advance. We won't know. And they're not going to bring the complaint to us because the Act provides avenue for them to go directly to a national tribunal. So any little gesture from us could become an escalated affair. It is something that could be taken to a tribunal, which has both financial and reputational consequences for the company. I can say there are other areas in which complaints can be taken to the tribunal, and that those include where the company has failed to implement a sexual harassment policy, or the company has failed to investigate a sexual harassment complaint. Those are also areas that employees can carry to the tribunal through a complaint, and their statute of limitation for that type of complaint to the tribunal is 12 months, not 6 years. So the question arises, Paulette indicated early in her presentation that the legislation has not yet received a commencement date. The legislation has been passed in both houses, but it is not yet enforced. And the date on which it will be enforced has not been disclosed as yet. So it certainly is something that could come about in the next few months. It could take a bit longer than that. But the question arises, when must a company implement its policy? And the mandated deadline is within 12 months from the date of commencement of the Act. That is the mandated deadline in the legislation. The consequence of failing to do so by that deadline is that the company may be found liable under the complaint process that I indicated earlier, and be fined up to $500,000 for its failure to implement a policy. Now, while this is the bare minimum requirement, it's the mandate set out by the legislation, I would say it's not the recommended course. it is not recommended that companies await the commencement date and then start counting 12 months thereafter before they put in place a policy. What is important is that the legislation has now outlined the exact rules that will govern your operation. So putting in place something now can be just as effective as putting it in place later. So it's always recommended to be ahead of the curve. So we've spoken quite a bit about the complaint process in relation to challenging the omissions of a company or challenging an offender who has committed an act of sexual harassment. But what happens when a complaint is made? What follows that complaint, especially the complaints that are made locally within the corporate structure itself? Well, the company has an obligation to notify the worker against whom the complaint is made within 2 days of receipt of that complaint. That obligation, as you can tell, is a very swift one. As soon as that complaint is lodged, you have 48 hours to notify the person against whom the complaint is made in a formal manner. We recommend the notification happen in writing. And it also begins, as indicated at the third bullet point on the slide, it also begins the investigative process. The company also must commence an investigation within 14 days of the complaint and complete that investigation without delay. At our middle bullet point, we see a slightly different factor where the complaint is made against a client. In that case, the client, of course, is not within the four corners of the company's building. So the obligation is that the company takes such action as appropriate to bring it to the attention of the client. It is left open-ended. Of course, that may entail using your regular communication channels to notify the client that the complaint has been made, because it is part of the employer's obligation to also investigate and to assess that type of sexual harassment, even if the offender is a third-party client. And it goes without saying, what happens if this is not done? If these requirements placed on the employer are not followed, what are the consequences? Well, an employer who fails to take the required action under the Act is liable for that failure, and a complaint can be made to the tribunal. The complaint will be investigated by a third party, that is an authorized officer who is authorized by the ministry to investigate complaints in relation to sexual harassment. And that person will have the authority to come into the company to interview members of your workforce, to interview the complainant, as well as the offender, the accused offender, which of course will be a very invasive exercise. It's not something we think companies should encourage. The employer, of course, will also be subject to a fine up to $1 million or imprisonment if it obstructs or assaults the authorized officer in the course of him or her executing her duties. So the consequences certainly are not small. And for large companies, hearing figures like 500,000, $1 million, or 900,000, which you will hear about later, these figures may not seem too intimidating, but consider this. Each of these fines may be imposed for a single complaint of interference within the workplace, or a single complaint that the employer has failed to take certain steps. So each time that an incident arises, you may be facing a separate fine that you are required to pay, and failure to pay could lead to imprisonment if the offender is an individual that can be identified.
Just to add, Jonathan, to that slide, it is extremely important that an employer observes the timelines provided in the Act. So as Jonathan would have mentioned, the investigation must commence within 14 days. The Act also requires the employer and the complainant to follow the local process. Now, if that employer fails to commence the investigation within 14 days, it automatically allows that complainant to take the matter from the local level straight to the tribunal. Yes. which a company may incur further costs, legal costs, and further exposure, as opposed to a matter that could have been dealt with within the four corners of its organization.
Yes, and I don't think we need to emphasize the ramifications of the exposure point. It's easy to read the legislation and to identify the fines in dollar figures, but the intangible consequences of this cannot go unnoticed. The reputational damage to companies, the personal reputational damage to individuals, to managers and supervisors when sexual harassment complaints are filed, are far more severe usually than the fiscal consequences. So it is our recommendation that we really stay ahead of the curve, implement your policies, ensure you follow your timeframes and your deadlines, and put things in place now, including the identification of a designated officer, whether that is a human resources officer to investigate these complaints and so, or to take information from anyone who feels offended. Those steps should be implemented now to avoid what this legislation is seeking to protect, to avoid sexual harassment. So we've discussed at length the avenue that the offended party can take to file complaints, but what then can a tribunal do in response? I can tell you these range of different remedies that the tribunal can award or that the tribunal can find are dependent on the nature of the complaint and the findings of the tribunal in relation to that complaint. So first, the tribunal can dismiss the complaint outright if it is unfounded. If the complaint does not have merit, if it is maliciously done. I know there are many examples we've read about where, someone lost their job, so they stirred up some trouble. They made false allegations and false complaints about their supervisors. They claimed things happened in the private office rooms and so, which were unfounded. In those instances, the tribunal is likely to dismiss the complaint. The tribunal can also order the respondent to cease and desist the offending conduct. Now, this type of order is what I would call a soft sanction. So if you take a complaint to the Sexual Harassment Tribunal and the tribunal finds that, for example, it was unintentional sexual harassment, as Paul had described earlier. So you are a hugger by nature, and you hug all of your colleagues, and everyone, they're accustomed to you. They know you don't mean it. They know you're not attempting to be inappropriate. But there is a new employee in the office, and she doesn't like it at all. And she thinks that no one should be in her personal space. This may be an example of unintentional sexual harassment because, as we indicated earlier, it is defined subjectively by what we can call the person a victim, by what the victim's experience is. So if that person is offended by your action, even if you did not intend that it be offensive, it can be considered sexual harassment. And it is my respectful opinion that if a complaint goes to a tribunal and it is established that it was truly unintentional, that it caused very little damage or very little harm, the tribunal is likely to take a soft approach and order that the respondent cease and desist the offending conduct before it moves on to awarding compensation, for example. So the tribunal can also order the respondent to perform any reasonable act or course of conduct to redress any loss or damage suffered by the complainant. What that means is that the tribunal has the authority to direct a respondent to publicly apologize, for example, or direct a respondent to remove some offending implement. If the sexual harassment example relates to the use of webcams or relates to the overlooking of the workforce in a layering manner, the tribunal can order that those webcams be deactivated. They can order that certain steps be taken to remedy or redress whatever damage or loss the complainant has suffered. And finally, the tribunal can award compensation up to $900,000. It's important, and we will discuss a little later on, the distinction between the criminal side of sexual assault and sexual harassment and the civil side of sexual harassment. And in this case, the tribunal deals with the civil side of it, where it awards compensation from party to party in a fixed amount. So the party who has experienced the harassment will receive that award from the party who has committed it. And if the committed party does not pay, the offended party can take the action to the Supreme Court to enforce it as a civil debt under the legislation. So what happens if a company does not comply? And we've discussed this, I think, a little earlier. The company can face fines up to 1 million or imprisonment awarded by a court of law. And let us be very clear here. This is now sanctions being listed for failure to comply with a tribunal's award. It is a little different from the sanctions listed for failure to follow the policy requirements or the procedural requirements under the Act. It is also different from the sanctions for committing an act of sexual harassment. So we have to keep in our minds these different categories demarcated. There is a requirement not to commit any act of sexual harassment. There's a requirement on companies to implement procedures and policies to avoid sexual harassment. And finally, where we are now, there's a requirement to follow any direction or order of the Sexual Harassment Tribunal if it gets to that stage. So if a company does not comply with such an order, it can also face fines up to $1 million, or imprisonment can be directed of the offended officer. The company can also incur millions of dollars in legal costs defending itself against a harassment complaint or a civil lawsuit. And the reputational damage that we described at length is sharpest at the end of a tribunal complaint. This is the point at which the gleaner and the observer is likely to carry the story. When the tribunal has made conclusive findings as to an occurrence of sexual harassment at the workplace, the reputational damage becomes most severe. So what is the other side of the coin? And this is important because we've discussed quite lengthily the avenue to bring complaints and to challenge incidents of sexual harassment. But we also know of false allegations that have been mounted and have caused significant reputational damage. So what is the consequence of making a false claim? A false complaint to the tribunal can result in a $1 million fine against the complainant, or that complainant may be liable to be imprisoned if they fail to pay the fine. So there is some protection here for the employers, for the managers, or for the individuals who are wrongly accused in instances where they can establish that no sexual harassment took place. So a person found to be willfully or knowingly brought forth, or to willfully or knowingly bring forth a false claim of sexual harassment against another shall be liable for a breach of the sexual harassment policy and for the breach of the legislation, and they shall be reprimanded accordingly. So what happens until the act has been given a commencement date? So I think we have captured quite a bit of what identifies and characterizes sexual harassment. We've also captured the consequences of failing to take your steps to implement a procedure and a policy when the act is enforced. And we've captured the procedures that must be followed before the tribunal and how the tribunal's awards should be respected. But until the act is given a commencement date, companies may take a slightly different approach. First, we recommend that you begin to sensitize your staff about the legislation. You begin to sensitize them about the scope of sexual harassment in Jamaica, about what it entails. I think one of the most staggering aspects of the definition of sexual harassment is that it is subjective. The most innocent act by an individual may be an unwelcome sexual advance to another. So that sensitization exercise should be very carefully explored. It should be done with attention paid to the definitions of sexual harassment, as well as the examples of sexual harassment in the Act. And the company should also follow its existing sexual harassment policy, if it has one, And if it does not have one, we strongly recommend that it be drafted now. You have the benefit of ascertaining the accurate requirements of that policy even before the act is given a commencement date, since the final legislation is now approved. And the final point, due process must still be followed. So this one indicates that in the event of a complaint in your work environment, even if sexual harassment law is not yet in force, complaints in the labor environment still require due process to be followed. They need to be lodged in an appropriate manner. They should be investigated. Investigative meetings should be called if necessary between the complainant and the party who has created an issue. And those meetings should be kept separated. You do not want to put them in the same space until you've gotten to the end of the investigative process. If you are considering separating an employee as a result of some element of harassment, you have to follow your disciplinary hearing process, and all of these regular labor requirements still remain in place even before the act is in force. So these are all a number of the avenues that can be adopted to prevent sexual harassment in the workplace. But how does an employer avoid it? We know the preventative measures that should be put in place. We also have heard about the redress measures that should be added to deal with instances of sexual harassment. But how do we avoid it altogether? How do we create that environment where sexual harassment is unlikely? We will say you must first assess what constitutes acceptable methods of communication. You must assess what is an acceptable level of physical interaction. You must assess whether the use of compliments or the use of comments in relation to the physical appearance of another is appropriate or is it inappropriate. And answering these questions puts you in the right path to creating that environment and that atmosphere that is free from sexual harassment. So let us explore it a bit. I think we have a little bit of time. We know that historically, the levels of communication that were acceptable differ from the contemporaneous reality. I think family members of mine say it the most. They say, people out here have gotten so sensitive. They take everything so seriously and they take everything so personally. And without stepping on any toes, I know that the different generations, the Gen Z population and the millennial population all have different sensibilities, which we need as employers and as managers to be cognizant of. So the acceptable method and levels of communication differ based on the audience that we are catering to. What the traditional people may have been comfortable with in the work environment, saying to someone as they enter, "That's a lovely jacket, Paulette. I love that color on you." And saying to someone else, "It looks like you've lost weight. Oh my, you must be doing something right." Those comments historically have not been considered to be inappropriate, but there are certain levels of sensibilities in the younger generation, I would say, that has led to findings that these comments were unwelcome, and that in a modern work environment, any level of commentary in relation to someone's physical appearance should be avoided. So it's very important to assess that method of communication and that level of communication in your workplace. Assess the type of conduct that can be taken by a recipient to be unwelcome. We are at the cusp of a transition in the legal arena on this topic. And at this point is a good time to do your surveys. Send out a questionnaire asking your employees, do you believe this is offensive? Would you welcome someone giving you a compliment in a work environment? And that allows you to answer these questions. Also, as a company manager, you can also consider whether physical interaction is frowned upon at a policy level. In your sexual harassment policy, you can decide that it was something that came out at the end of the COVID-19 period, that physical interaction really is not necessary for a healthy work environment. We've been working at a distance, and we've been very successful at doing so. So we can consider whether it is a safer work environment where a policy is introduced that discourages physical interaction altogether, or on a case-by-case basis in your individual environment, you can consider whether that is a little too onerous, whether you welcome a little more friendliness. So what we recommend in relation to acceptable communication and conduct, you can be friendly, but avoid sexual innuendo. Do not make jokes in relation to physical appearance that can in any way be perceived to be sexual in nature. Do not use puns, do not use any innuendo that raises a question about someone's sexuality or someone's sexual preferences, someone's sexual appearance, or anything of that nature. Also, do not initiate physical contact. As I indicated briefly earlier, it absolutely is just not necessary in the work environment any longer. It is something that you can, on a case-by-case basis, dependent on the relationship that you have with individuals, it's something that you can traverse carefully, but what is safer is to avoid it altogether. And if another party initiates physical contact, you can respond in a friendly and non-sexual manner. This even includes shaking hands. There is a question that arises as to whether someone shaking your hand and holding your hand for too long, or shaking your hand and rubbing a finger against part of your hand could be perceived as sexual harassment. And again, the question is not what was intended by the person acting, but how it was received by the recipient. And if the person finds that your hand holding lingered for a bit too long, your eye contact while shaking hands was a little too piercing, you know, these types of words may be thrown around, then it may in fact amount to sexual harassment that could create some difficulties for you.
If I could just add, Jonathan, that this is not a change that will take place overnight. It will take a culture change. Yeah. We as Jamaicans here, we have a tendency, for example, if somebody is pregnant, you see a pregnant lady, you're tempted to touch the person's tummy. Now, that sort of behavior may be okay, you know, amongst friends outside of the working environment, but that's not something that you would initiate in a working environment. I'll give a very simple example. In some employment contexts, persons are required to wear a name tag, right? If, for example, I'm wearing a name tag and my name tag is falling off, what do? Do you say to me, Paulette, your name tag is falling off? Or do you take the initiative to assist me in fixing my name tag? Now, if you take the initiative to fix my name tag, that would require physical contact. And as Jonathan said earlier, you know, do not initiate physical contact, because on your part, it may seem innocent to you. You are merely assisting me to fix my name tag. However, for me, it may be perceived as you using it as an opportunity to make physical contact with me, particularly on my upper body part. So it is going to take a culture change, and it's not something that happens overnight.
Right. Yeah, and I think that last comment also is still very relevant. The recommendation to not text compliments to a staff member to make sexual suggestions. Now, it need not even be sexual. We know we are in an environment where adults have the freedom to get to know each other and to become friendly. But the exchange of compliments may be perceived as unwelcome depending on how it's done and depending on who the recipient is. So take, for example, you send a regular text message to a colleague to say, you look stunning today, or you look lovely in that dress. And you exchange this compliment repeatedly, perhaps even on a daily basis. You send a single text message and you think you're being charming, not overbearing. You send this single text message on a daily basis. The course of conduct at that point may be interpreted by a tribunal to be something that it constitutes sexual harassment, even if the compliments themselves are not sexually suggestive. So it's very important that we are careful with each of these elements and that we perceive openly and candidly what is welcomed from the person with whom we are communicating. Of course, being absolutely unfriendly is the safest bet, but perhaps not the most accommodating to the work environment. We do have to remain cordial with our colleagues. So you have to tread the line carefully, and we recommend that you don't text compliments to other staff members, and certainly not to make sexual suggestions. So I'm going to ask Paulette to take us through this image. Let's take, for example, if this was in a text message between coworkers.
Right, we're in the age of technology. You know, persons use their iPhone on a daily basis. Jonathan comes to work. I text him immediately after he enters the building. I text him this emoji. Is this appropriate, Jonathan? Would you conceive this as sexual harassment?
Should I comment?
Yes, you can comment.
I feel a little put on the spot, but I must say, I would think this to be an unwelcome sexual advance, particularly because of the tongue extended out of the mouth of the heart. I think it is pushing the boundaries a little too far in relation to what is appropriate in the workplace. There may be other recipients of this image who welcome it, who do not think it inappropriate or unwelcome, but it's more likely than not that it would be considered sexual harassment when sent to a work colleague. Now let's take this one that is less overt. Here we have a thermometer. In regular text speech, this means hot. If you send a thermometer to a colleague by text message, and if I were to send it to you, Paulette, would you consider this to be sexual harassment?
Well, it depends on the context, Jonathan. If you're seeing me for the first time for the day, like in the scenario mentioned just now, I step into the building, you text me, you send this emoji to me. It may not be appropriate in the working environment.
But would you welcome it? Would you?
It implies hot. What is hot?
Yes. Yeah. So.
But again, what may be perceived, maybe I perceive it as harassment, but to another person, it's, you know, they could welcome it.
Right. So again, the thing we would like to hammer home about these images and about text messaging and about how you communicate with your colleagues is that you need to tread carefully. There are actors in the work environment who would send this image, and in their mind, they can explain 10 different reasons for why this is not harassment. And they can say, it is just a bulb with an extension. I don't even know that it was a thermometer. I didn't intend it that way. It was not expressed with any other language. I simply sent this to see what the person would send back. It was a joke. It was a typo. All of these explanations could be used, and none of them, absolutely none of the explanations would justify the action if it were taken before a tribunal and if a recipient said it was unwelcome and they considered it a sexual advance. So that subjective nature of sexual harassment is, I think, the prevailing idea that we need to appreciate and use it to inform the policies we introduce, use it to inform the environment we seek to create, and use it to discourage action that may be perceived as unwelcome. So it takes us to the next step. If there is an actual incident of sexual harassment, what do the managers or supervisors do when they observe that behavior or when they heard that the action took place? This is recommended steps that a manager or supervisor can take. They include getting context, asking the employees if everything is okay in relation to what was exchanged, speaking to each employee away from the other so that the information divulged is private and confidential, reporting the matter to human resources or to another delegated authorized officer within the entity, after speaking to both employees, if there is a concern about that one of the employees' behavior. So certainly you don't wish to escalate it if it is a non-issue for the parties who are affected. If the people involved do not take offense to the conduct, there is no need to escalate it further. But if it's the recipient of the information is offended, it raises the obligation on the company to proceed to the investigation stage and to proceed to taking a complaint in writing. And finally, do not take any steps to punish the employee. Let's be very clear here. This is a reference to the person who is making the complaint. No steps should be taken to penalize the complainant in relation to an incident of sexual harassment. And that happens most regularly in instances where the complainant is complaining about the conduct of a supervisor. The senior individual has done something that the complainant is offended by, even if the senior individual didn't intend it to be offensive. That person may think that this is now a vindictive measure on the part of the employee. But it is important at that point to clear the air, to keep the environment welcoming, and to advise the employee that they will be free from any employment penalties as a result of their desire to explore the sexual harassment procedure. And we go back further to the discussion on how to prevent harassment in the workplace. Now, based on what we just discussed, if you have observed harassment taking place, it is already too late. And this is why we preach the message that prevention is better than cure. Preparation for every situation of possible harassment is also impossible. So we can appreciate that we must put forward our best effort to put in place policies and to create an environment and an atmosphere that is welcoming for our employees to speak about sexual harassment issues and to make complaints if necessary. But it is not possible to prepare for each and every possible situation. There is no way to guarantee that an employee will not look at another employee for an extended period and cause offense. It's just not possible. So to avoid situations of possible harassment, staff should feel that they can communicate with management openly, that they can communicate about interaction, even if the interaction involves supervisors or other managers. And what is most paramount about this aspect is creating that culture in the workplace where sexual harassment is not a taboo topic, where employees are not afraid to come to you and to explain that this is happening and I don't feel comfortable that it is happening. And that, I think, is the best way to prevent harassment altogether, when you've created that new culture and created that new environment where this topic is not taboo and it is open for parties to discuss. So we indicated earlier that there is a need to identify the distinction between sexual assault and sexual harassment. Sexual assault is the criminal sanction that may follow if a complaint of some sexual interference is taken to the police. And sexual harassment is a civil liability issue that may be taken to the Sexual Harassment Tribunal, and it may require the complainant to progress the matter through the tribunal in order to receive an award to be paid by the offender. So the sexual assault aspect of it, which we may all be familiar with, is an aspect that exists notwithstanding the fact that the sexual harassment legislation is not yet in force. The sexual assault criminal sanctions still exist. You can be arrested, charged, and convicted if it is raised, taken to the police, and proved at a criminal trial. The sentence for grievous sexual assault can be up to life imprisonment. So the consequences of serious sexual action, unwanted sexual action, can be very severe. And sexual assault involves unwanted touching or forced sexual acts. It goes beyond the sexual harassment thresholds, which can be verbal, non-verbal, gestures. They can be virtually any form of interaction that is unwelcome. So we've come to the end of the substantive aspect of our presentations. Before I close on our overview, I know that Chris Jarrett indicated earlier that there are a couple prizes that the JCC and their sponsors secured for our participants, a couple gift baskets. So those gift baskets will be awarded for the participants who give us the best answers to the questions that follow these slides. And we're going to give you the opportunity to provide those answers in the chat window in our Zoom platform. So you can prepare yourselves to address these questions, and hopefully you will have an opportunity to win a basket. I will also be asking an impromptu question after the two to see if you've been paying attention. All right. So today's overview. At this point, the sexual harassment legislation is not yet in place. It is, however, finalized. So we are at the place and the point where we can implement policies and we can take steps to create an environment that complies with the sexual harassment law. But the first step we recommend is that you communicate and sensitize your staff. We recommend that that be the first initiative. Do your surveys if necessary to identify what levels of communication are welcome in the workplace, to identify if physical interaction should be banned altogether, because the safe implementation of the sexual harassment law requires an understanding of what would be welcomed or unwelcomed by your employees. So start with communicating and sensitizing your staff. Second, design a sexual harassment policy. A lot of the companies in Jamaica already have labor and HR policies that cover this topic, but it may need some refinement. You may need to implement the specific ingredients set out in the legislation, which includes identifying the procedure that should follow a sexual harassment complaint, identifying to whom the complaint should be lodged within the local space, notifying employees that they can take complaints to the tribunal if the offender is the employer, or if the action is not being investigated or pursued by the company appropriately. And it goes on. So these are all core elements of what the policy entails. And third, and most importantly, for our employers and managers, lead by example. Ensure that your own conduct is exemplary and that you set the tone from the top for your workforce to follow. So those are our core recommendations from this presentation today that address initiatives that should be taken now before the sexual harassment law is enforced, and it allows you to protect yourself to the greatest degree possible. So let's have a look at a couple of our scenarios. Paulette can take this one, and please remember, provide your responses in the chat window, and I think the best response may be subject to win a basket from the Jamaican Chamber of Commerce's sponsors.
Okay, so scenario number one. Lewis and Keisha work at a retail store. When Lewis first started, they went out on a date, but decided that they wouldn't take things any further after that. Recently, Keisha started pressuring Lewis to go out on another date, even though Lewis now has a partner. Keisha later parks her car on the street outside his house, and she waits for him to go out to bump into it. Now, let us examine this scenario. Are there any elements of sexual harassment taking place? So, one, they're both co-workers. They both work at a retail store. Two, they first started dating, right? They agreed to go out. There was consent. Three, they decided that they would not take things any further. Therefore, there is no longer consent. Now, Keisha clearly is not, she's not okay with Lewis's decision. And she knows that the pressures Lewis to go out on another date, even though he has a partner, and even though he is no longer interested in dating her, despite the fact that he went on a date before. Now, the fact that Keisha has started to pressure Lewis constantly to go on a date, could this be considered sexual harassment? In my opinion, the fact that she's constantly asking him or pressuring him to go out on a date, that could be considered sexual harassment. It matters not that the request is coming from a female. Keisha takes it further. She parks her car on his street. Now, this is another form of sexual harassment. It is stalking, right? She waits for him to come out, and then she bumps into him. So we're seeing different elements of sexual harassment here. This now is physical harassment, because she's now bumping into him at his house, right? Now, what happens now if, for example, Lewis did not see Keisha parking outside and Keisha did not bump into Lewis? Would this still be considered sexual harassment? Would Keisha visiting Lewis's house, parking outside his house, would this be considered sexual harassment? Well, earlier in the presentation, we mentioned that sexual harassment is in the eye of the beholder.
Oh, hold a second, Paula. Before you answer, I'm hoping we have a couple participants who can provide their response in the chat window.
Sure, before I give away the answer.
Yes, before Paula just gives away our basket for free. So the question, guys, is if Lewis in this scenario does not see Keisha outside of his house and he does not bump into Keisha, is it still sexual harassment? Please provide your response yes or no and your reason so we can assess which answer we like the best.
Most persons said yes. Tony Spencer says Keisha is now stalking Lewis and Lewis can claim harassment. Lorraine Curran says yes, stalking and unwanted advance. However, there's a long response from Edmundo Gines. He says cultural transformation will be a significant challenge. For example, since sexual harassment is in the view of the person receiving the advance, the matter of sexual presentation by means of forms of dress or conduct may be perceived by some as modes of sexual invitation.
Okay, it sounds as though Edmundo's comment is on a slightly different topic. And the names prior, you said Keisha had given an explanation, and what was the other name?
Tony Spencer.
So we have from Keisha and Tony. Thank you so much for your feedback, everyone. We have two explanations from Keisha and Tony that both indicate, yes, it is sexual harassment, and their reasons for stating so. Do we have any other responses from participants?
Ava Big B says no, cannot charge for what he's not aware. Simone Dunbar says her actions have escalated from stalking to something physical. And Ika Prendergast says pressuring him the date can be considered forced coercion.
Good. So the people who are commenting on the pressuring aspect are still very correct. I will let Paulette give her explanation, but I think I have my winner. I like one of the answers already.
Somebody queried Dr. Williams, she says, but parking is not done near the workplace. She's outside of the workplace. Is that still harassment in the workplace? All
right, so that's an interesting question. Let's keep it for our question and answer. And I will let Paulette address her mind to the response. Is it sexual harassment if Lewis does not see Keisha outside of his house and they do not bump into each other?
Right. So I'm going to take you back to the definition of sexual harassment. So it has to be an unwelcomed sexual advance. And look at the effect. It has the effect of making the recipient uncomfortable. Now, if Lewis is unaware that Keisha is parked outside, and if Keisha doesn't bump into Lewis, then Lewis is not, there's no feeling of discomfort. There is no knowledge. So in that context, I would not consider it as sexual harassment. However, the aspect of it in relation to Keisha's constant pressures to go out on a date, I certainly believe that that is considered sexual harassment.
Good. So our responses from those who commented on pressuring are still very correct. But I believe the name was Ava Bigby, who said, no, he cannot charge for what he does not know. And that is a simple way of saying, if the recipient has not received the contact that the person is making, it cannot be sexual harassment under this law. Ava, congratulations. So we will tackle our second scenario. This one is mine. So Janice is a receptionist at a dentist's office. Jason, a gay dental assistant, often asks Janice about the upcoming appointments. Every time she comes by, he will take Janice's hand and examine her nails closely while complimenting her on how well manicured they are. Janice on one occasion told Jason that she doesn't like having anyone touch her hands, but Jason continues to do so on every occasion, and Janice hasn't objected since. So this one is very interesting. A couple key elements. They are work colleagues. Jason is gay. He is not, for intents and purposes, interested in women. And every chance that he gets, he holds her hand and compliments her nails. She said on one occasion that she does not like to have anyone touch her hands, and he continued to do so. The curveball, Janice has not objected since. Can this physical contact from an individual who is not sexually interested in Janice for the purpose of this scenario, can this physical contact be considered sexual harassment? Please feel free to provide your responses in the chat window along with your reason why.
Cheryl Campbell says, scenario 2, yes, it's sexual harassment, and she has stopped saying it's unwelcome.
It is sexual harassment and she has stopped?
No, it's not.
It's not.
She says no, it's not. Okay. That's the only response thus far.
Okay, so the only response we have so far is no.
Anika Prendergast says yes, as she expressed discomfort and the behavior continued. Simone Dunbar says yes, it is she's uncomfortable. Ava Bigby says yes, she's uncomfortable and has stated that she does not welcome the touching. Desney Johnson says yes, it is harassment, it is an unwanted advance. Carol Williams says yes. Melissa says yes, doesn't matter if the person is gay or straight.
Good. So we have responses from around 6 different individuals who say yes and 1 individual who says no. First, my view is that the individuals who say yes are correct. It is not a requirement for the person who is doing the act to be sexually interested in the person who is offended. As we indicated earlier, the test is a subjective one using the persona of the offended person. It is based on their experience and not the person doing it. So it is a similar example to unintentional sexual harassment, where you did not intend your advance or your physical contact or your comment to be sexual in nature, but it was taken that way. So the persons who say yes are correct. I believe all of your reasons for saying so are correct as well. So my preference would be to award the prize to the first person who answered correctly. Our marketing manager can indicate. Melissa White, a colleague who used to work at DunnCox, coincidentally, if it is the same Melissa White. Congratulations, Melissa, your answer is correct. So we will move into our question and answer segment. At the end of this segment, I may have a question for you as well. But again, thank you so much for listening, and please do go ahead and ask us your questions and we will take them one at a time. So Cheryl Campbell asks, what determines the commencement date? We've waited long enough for the passing of the legislation and have to wait for a possible further few months. And that is regretful, but true. It is up to the parliamentarians to determine when the commencement date will be. And it is something that is a long time coming. But as we indicated throughout the presentation, you don't have to wait on it to put in place the policies necessary to be compliant with the legislation. There is nothing magical about that commencement date. Simply implementing the policies now will be the safest practice, and it protects you going forward.
Right. And just to add to that, oftentimes legislations, though implemented, it requires additional things to be implemented. So for example, in this legislation, it establishes a sexual harassment tribunal. So that's perhaps maybe one of the things that is required to be implemented before a commencement date can be issued.
So Cheryl also asked, in respect to point number 2, I would say review the existing policy to ensure compliance with the new legislation rather than just comply with the existing policy. It seems that that is a comment from Cheryl. She's recommending that the existing policy be reviewed as opposed to simply ensuring compliance. We have a question from Simone Dunbar. What determines the commencement date? Again, this seems to be one we've already answered. We can turn to the question from Tony Spencer. Tony is asking whether the company needs to identify an accountable officer. An accountable officer is a notion that exists under other legislation, but in this one, I would call the person a delegated responsible officer, and that would be an individual who's responsible for hearing sexual harassment complaints and investigating those complaints. In large companies, it could be the human resources manager. In small companies, it's a senior manager who handles the labor issues within the structure of the entity. Paula, you can also take.
Bulla McKay question is, if team members are shunning someone who has complained, does the act speak to this? So the act doesn't directly speak to other team members shunning someone who has complained, but it establishes the right to an environment that is free and safe from sexual harassment. So there is no specific aspect of the legislation that speaks to that. But I would suggest that as employers, we begin to sensitize our staff that we create a culture which welcomes such complaints, so persons would not be shunned.
Yes, so you cannot in any way control each and every employee's reaction to something that happens in the workplace, but you can, from the top-down approach, control the culture. And Paulette is very right. That will be a good measure to avoid employee-to-employee embarrassment or degradation as a result of sexual harassment. There was also a comment from one of our participants, from Coran Robertson Sylvester, who commented that the second emoticon we utilized, the thermometer, could have been used to indicate that the air conditioner isn't working, for example. And that is very correct. Right. So Cora Ann's view is that the subjective element of the legislation is tough. It's that it's challenging.
Right. I must add to that the legislation does say that to determine whether or not a particular act is deemed sexual harassment, all the circumstances must be considered. So, you know, we have to consider the context of that particular situation. So if you're referring to the AC being broken at a time it's hot in that context, then a tribunal could not reasonably find that that was deemed sexual harassment.
Yes. So if a complaint is made, perhaps it's not one that would get very far.
Right.
All right, so we have another question coming. So Dadra Williams indicated, how is the employer liable for an action that happens outside of the company? For example, the lady in the scenario who went to the home and parked outside. Okay, so this is important for my aspect of the presentation. The employer is not liable for the sexual harassment of an individual in the workplace. The employer, the company, may be liable for failing to follow policies and procedures that they should have followed under the legislation. So the employer's obligation when an individual at work or outside of work harasses another individual at work or outside of work could be to investigate the complaint, to penalize the individual within the employment structure, and to avoid instances where the tribunal has to get involved for the company's failure to take those steps. So those are the obligations for which an employer can be liable. But as we indicated earlier, the actual offense of committing a sexual act that is unwelcome is an offense that will be faced by the individual who committed it and not by the company if it happens within or outside of the corporate structure.
And just to add, it doesn't matter whether it is the act is committed within the four walls of the organization or it is committed outside. Because if a supervisor invites another, his subordinate to lunch or to dinner, that is an act that could be considered sexual harassment, and it is taken outside of the four walls of the company. So it is not limited to a physical location within the organization.
Okay, so Antoinette Lawrence has asked that we type one of our answers. We will be happy to do so after the session is concluded. And I think that may be the extent of our questions thus far. Olive Downer Walsh has asked, is there an aspect of the act that allows for clear differentiation of instances in which persons with claims of sexual harassment may have provoked through blatant discrete actions? This is an interesting question. Is there an aspect of the act that allows for clear differentiation of instances in which persons with claims for sexual harassment may have provoked through blatant or discrete actions? It sounds to me as if the question is asking whether the act differentiates between sexual harassment that is unprovoked and sexual harassment that is provoked by the person who is complaining about it. And my response would be that the act does not make that differentiation. On each incident of sexual harassment, once a complaint is lodged, that person is considered to be the victim in relation to that complaint, and the accused offender will be scrutinized for their conduct. But as Paulette indicated, all of the circumstances of each individual case will be considered. So as evidence as to whether the conduct was welcomed or unwelcomed, as an illustration of whether it was provoked. I mean, provoking sexual harassment is a strange notion in and of itself, but perhaps someone could have enlisted or solicited for that approach. The person could have flirted first, and when you reciprocate, they then complain of sexual harassment. All of those circumstances will be factored in to consider whether it is in fact an unwelcomed response from the accused offender, and it will also determine what type of sanction the company or the tribunal imposes as a result.
And just to add, in that scenario, a particular individual could have encouraged a particular sexual conduct on one occasion, and then on another occasion where they did not encourage it, but because you did it on a previous occasion and the person did not react negatively towards it, it doesn't mean that on the second attempt of doing that particular act that the individual, or as Jonathan would have deemed it, the victim, would have not deemed it sexual harassment. So again, it's very subjective. What may be considered sexual harassment today may not be considered sexual harassment tomorrow, even if it is done, the same act is done to the same individual on more than one occasion.
Right, so we also have a question from Tony Spencer, who asked whether a retailer would be considered a contractor for the purpose of the legislation. I assume the question is connected to the classification of workers and employers and contractors, in which case the retailer, if the retailer delivers items to a company and then is involved in some sexual harassment type allegation, it is my view that the person would be considered a contractor. They are performing a service for the entity, It is, of course, a broader employment question as to the nature of that service, whether there is a contract between the company and that retailer under which a contractor relationship exists. And if there is, that retailer could be considered a contractor. Tony Spencer also asks whether the Act extends to companies owned outside of Jamaica. As you may appreciate, Jamaican legislation is confined to this jurisdiction. So if the companies that are outside of Jamaica typically do not fall under the jurisdiction of Jamaica, but if the act occurs within our shores, if the act involves an employee of an overseas entity and a Jamaican employee, that may be a separate issue and it may fall within this jurisdiction. Carol Roden, and this one, Paulette, I think I can comment to you. Are companies responsible for harassment which takes place between staff outside working hours? What are your thoughts, Paulette?
Sorry, can you repeat that question?
Are companies responsible for harassment which takes place between staff outside working hours?
Yes, they are. It doesn't, again, it doesn't matter. The venue doesn't matter and the hours doesn't matter. So it could be at 10 o'clock, even if your working hours are 8 a.m. to 5 p.m.
Yeah. And again, that question about are the companies responsible? That responsibility is a responsibility to take certain steps in relation to a complaint. So how it would typically go is if action takes place after work hours between two staff members and a staff member returns to the company and complains about it, that is where the responsibility arises on the part of the company to handle that complaint in accordance with the rules of the legislation. So I think that is the extent of the questions that we've seen. If you do have any further questions, of course, our contact information can be made readily available. Our PowerPoint presentation will also be shared, and you can reach us through the Chamber of Commerce for any further questions or concerns that you do have in relation to this topic. So on our part, we want to thank you all for participating. We think it was very engaging. I believe we have 2 winners of awards already. And for the 3rd winner, I would ask for the audience to type the definition of sexual harassment given earlier in the presentation in the chat window, and the first accurate response shall receive our 3rd prize.
That's a tough one, Jonathan.
I mean, if you were paying attention,
That's a very tough one.
I'm sure a couple participants took screenshots or photos of the PowerPoint. Anyone who can type a relatively accurate definition of sexual harassment is likely to win the 3rd prize from the Jamaican Chamber of Commerce sponsors. Again, thank you so much. You can feel free to send your responses to that last question while we sign out with Christopher. Again, it's been our pleasure. Over to you, Chris.
Thank you, Jonathan. I heard Jonathan inviting our participants to, if they have further questions, to contact him afterwards, but I might wish to advise you that I don't believe that his time is going to be free. Yes. Okay. All right. So the Chamber wishes to thank all our presenters, Mr. Jonathan Morgan and Ms. Paulette Neal, for their comprehensive coverage of the subject. We wish to remind the attorneys who are participating today to note that the Jamaica Chamber of Commerce, will be submitting documentation from the webinar to the General Legal Counsel for consideration in continuing education credits, and to complete the evaluation form and submit same via email to andrea.waite, andrea.waite at jamaicachamber.org.jm. Also, we want to take the opportunity again to thank our sponsors, CarbMed and Pyramid Limited and IGL Limited. And we want to advise the participants that the recording of the presentation will be available through the Secretariat at the email I just outlined at the Jamaica Chamber of Commerce. Now, we heard earlier about in the presentation the example of Governor Cuomo, and particularly as Jamaicans, culturally speaking, we are, and perhaps our Caribbean peoples generally are very touchy-feely type of people. And today's webinar has been instructive, I think, and very useful for all parties concerned in guiding how it is that we govern our behavior and actions and reactions in the workplace, and of course, the recourse that will be available to both the employer and employee. We're hopeful that some clarity has been added to reduce the blurred lines that exist in this regarding this very complex subject. The takeaway, in my view, is that the recognition that there are several factors such as tone in the way that we communicate, the frequency of the conduct or advance that might be considered aberrant, whether the action is offensive, whether the action is humiliating, whether the action is uninvited and therefore unwelcome. It is advisable to, as you heard outlined by both the attorneys, that a policy guideline document be created by employers and perhaps developed with the participation of the participation and input of the employees. So again, thank you all for participating, and have a wonderful day.
Chris, thank you as well. All right, so long, everyone.